Did you know you can follow Virginia cannabis law perfectly and still lose your job? Here's why. This is the unresolved legal outcome. Your employer, in Virginia, can have a zero-tolerance cannabis policy that applies to your legal, off-duty, private conduct. And that policy, that termination, can be upheld as perfectly lawful even if you never possessed or consumed on company property, and were never impaired at work. The state law allowing possession creates no private right of action, no wrongful termination claim for most employees. We'll return to the exact legal mechanism that makes this possible, and who, if anyone, has a sliver of protection. So, the counterintuitive legal fact is this: Virginia decriminalized cannabis possession for adults, but it did not legalize workplace use, or require private employers to tolerate it. Not even a little bit. This challenges a belief you likely hold, and it's a critical one to address up front. If it's legal for me to have at home, my employer can't punish me for it. That belief is, well, it's understandable, but it's legally incorrect in the Commonwealth of Virginia for the vast majority of workers. And clinging to that assumption is where financial and professional risk silently builds. Welcome to Norfolk, Virginia Cannabis Hub, where we focus on Virginia-specific cannabis law, local governance, and regulatory clarity, so residents, business owners, and communities understand what the law actually says, not just what headlines suggest. I'm your host. This video is a legal analysis of employment at-will doctrine, drug-free workplace policies, and the specific intersection with Virginia's cannabis statutes. This is educational, compliance-focused, and Virginia-specific. It does not encourage use, and it does not give legal advice. Stick around for a real-life scenario we will share with you. Now, here's the context for why this legal issue exists in such a stark form. Virginia is an employment at-will state. That means, absent a contract or a very specific statutory exception, an employer can terminate an employee for any reason, or for no reason at all, so long as it's not an illegally discriminatory reason. Race, religion, sex, those are protected. Your legal, off-duty use of a substance that is still prohibited under federal law? That is not a protected class. This at-will doctrine forms the bedrock. Layer on top of that the federal conflict: cannabis is still a Schedule I controlled substance, and you have a perfect legal storm that allows, and even encourages, employers to maintain strict policies. Alright, so here's the legal explanation. The relevant Virginia statute, Code of Virginia Section 40.1 to 27.4, does provide a narrow safeguard. It states that an employer cannot discharge, discipline, or discriminate against an employee solely for that employee's lawful use of cannabis oil pursuant to a valid written certification issued by a medical practitioner. That sounds like a protection, but it's legally true, yet operationally misleading. The keyword is solely. An employer can discharge you for a positive drug test that reveals those same cannabinoids if the policy is applied neutrally. They just can't say the only reason was your legal medical use. This is where most people stop learning, and where problems start. This introduces our second loop: enforcement discretion, or rather, policy application. How employers enforce these rules. It's not about police, it's about HR manuals and onboarding paperwork. Complaints or investigations often begin with a positive test following an incident, a random screening program, or reasonable suspicion. Now, the science is critical here. Most standard drug tests do not measure impairment, they detect inert metabolites that can be present for days or weeks after use. A positive test is not evidence you were high at work. But under a typical zero-tolerance policy, it is definitive evidence of a policy violation. The lab report is determinative for your employment, even as it would be meaningless for a criminal possession case. And this brings us to our third open loop, the consequence loop: who this affects. It's not one group. For the general employee in Virginia, you are likely at will and vulnerable to a policy you may have hastily acknowledged during onboarding. For safety-sensitive workers, think truck drivers under DOT regulations, heavy machinery operators, nurses. The federal rules often mandate a zero-tolerance stance, completely overriding state law. For medical cannabis patients, you have that thin statutory mention, but the burden to prove you were fired solely for that status is exceedingly high. And for employers, especially small businesses or federal contractors, they are navigating their own liability, often erring on the side of restrictive policies to protect federal funding or insulate themselves from workplace accident lawsuits. Let's pause right here. This is the mid-video inflection point, the most important clarification. We've talked about the law, about policies, about who's affected. But now we reframe from what the law says to how this plays out in a real career. The tension isn't between you and the state. It's between you and your employer's interpretation of risk. And that interpretation is almost always going to prioritize the company's legal exposure over your personal, legal activity. Why does this matter so much? Beyond the immediate financial shock of job loss, it matters for regulatory clarity. We have a state law that implies a personal freedom, but a private sector landscape that can nullify it for economic survival. The long-term policy implication is a workforce operating under two conflicting sets of rules, where the private employer's rule holds the tangible consequence. Now, let's resolve our primary open loop with a scenario example, the legal payoff. Earlier I mentioned the mechanism that makes this possible. Let's walk it through. Scenario A. Alex is a sales associate at a private Virginia company, not safety sensitive. Alex uses cannabis legally at home on a weekend. There is no impairment at work on Monday. On Wednesday, a workplace accident unrelated to Alex occurs. The company's blanket post-accident testing policy requires a urine test for all employees on the floor. Alex tests positive for THC metabolites. The company's written drug-free workplace policy, which Alex signed, states that a positive test for an illegal drug is grounds for immediate termination. The company terminates Alex. Alex sues for wrongful termination. The court will likely side with the employer. Why? Virginia is at will. The company had a neutrally applied policy. The test showed a substance illegal under federal law. The statutory protection for medical use doesn't apply because Alex wasn't a patient, and even if they were, the company could argue termination was for violating the policy, not solely for the medical use. Contrast that with Scenario B. Blake is in the same job, but is a registered medical cannabis patient for PTSD. Same positive test after the same accident. Blake is terminated. Blake sues, citing Section 40.1 to 27.4. The employer argues Blake was terminated for violating the uniformly applied drug policy, not for their medical status. The court now has to untangle solely. This case is less certain, far more costly to litigate, and hinges on specific evidence of the employer's motive. But the burden, the time, the legal cost falls on Blake, the unemployed individual. The employer's position is structurally stronger. The small legal distinction, the word solely, the presence of a federal contract, the type of test used, changes everything. Not because the possession law is different, but because employment law operates on a separate, parallel track. Here's what to watch next. If your employer can do this based on a test, what about based on smell? The issue of odor is probable cause for an employer's reasonable suspicion test, or even for a police call, creates another dangerous gray area, especially for renters. That's a logical follow-up. Here's a question to think about. Do you know what your employer's cannabis policy actually says? Have you read it since the day you were hired? I welcome respectful discussion in the comments below. Have you or someone you know navigated this issue in a Virginia workplace? What other employment law gray areas would you like us to analyze? If you found this legal breakdown valuable, please like, comment, and subscribe for more Virginia-specific clarity. For deeper dives into policy language, case studies, and community dialogue, I encourage you to read the full analysis on our site and explore the Norfolk City Cannabis Community Forum. Remember, this is for educational and compliance purposes only. Know your rights and your risks.